So, chapter 20, transfer of title. In this chapter, we're going to learn about the four methods of title transfer, which we kind of already touched on and learned in earlier chapters. We're going to explain the process of transfer of title of a deceased person's property as well. So, title to real estate means ownership of the land. Remember, there's no document in real estate actually called title. Title is just a document, is a term used to describe ownership. And alienation is the transfer of title to a parcel of real estate. This can be done during the lifetime or after one's death. It can be done voluntarily or involuntarily. At death, it's voluntarily done through a will, or involuntarily if no will is left, because the state will get the process, will get it through the process of escheat, if no heirs can be located, and if you died without a will. So let's highlight and make this note here. So voluntary alienation of title can be done by gift, sale, or exchange. Owners use some form of deed to convey the ownership during the lifetime, or by a will to transfer voluntarily upon your death. Transfer of ownership to or from the government is done by either dedication or public grant. Dedication is when a private individual gives land to the government for a public use, such as streets, schools, or parks. Public grant is when the government gives publicly owned land to an individual for private use. Rain freeze, okay. So let's do the highlights here. Involuntary alienation, what dedication and public grant is, and involuntary alienation and escheat. Okay, everybody got that?
I got it.
One more second.
Sure.
Okay, got it. Thank you.
You're welcome. So involuntary alienation is a transfer without the owner's consent. And this can be done by escheat, eminent domain, unpaid debts, by foreclosure if you don't pay your taxes or your mortgage loan. It can be done by a court action called a partition proceeding or suit to quiet title. By adverse possession. This is known as an easement by prescription, and it must be perfected with a lawsuit for adverse possession. Some people refer to it as squatters' rights. And erosion by Mother Nature. a decrease in land caused by the wearing away of the land by wind or water. That's a form of involuntary alienation, I guess. Mother Nature taking it from you. So page 375 on the second paragraph, a partition proceeding. One co-owner sues the other, forcing them to divide or sell the property. So when you got one owner that wants to sell and the other does not, are you stuck owning a property with them? No. You could ask them to buy you out, or you could try to sell your ownership shares, your partial ownership interest to someone else. But that may be difficult to do to find a buyer who's not going to own the property completely. They'll have a partial ownership with someone else they don't know. That may be a little difficult to do. So the other option is then to take them to court. A judge will see if the property can be subdivided and deeded. And if that's not possible, then they order the property sold, and then the proceeds will be split according to their ownership interest. So that's known as a partition proceeding, where they're going to partition the property if possible. So here are some forms of involuntary alienation. When a person dies intestate and they have no heirs, the property will escheat to the state. It'll revert to the state. If land is needed for a greater public good, through the powers of eminent domain, a condemnation suit can be instituted and payment of compensation to the property owner for the taking of the property, and then the public or governmental agency that needed the property will get it. Non-payment of debt secured by real property is done. The property will be taken through foreclosure, and a sheriff's department will sell it off to the highest bidder. Or through open, notorious, continuous, hostile, and adverse use of another person's property for a prescribed period of time. An easement by prescription could be achieved through a lawsuit for adverse possession, in which case the adverse possessor will now become the owner of the property. That's squatter. So you guys already highlighted this, right? In a partition proceeding, one co-owner seeks to force another to divide or sell the property. All right, so okay. So easements by prescription. This we're going to go over in chapter 6, I believe. 6 or 7. Chapter 6, I think. So chapter 6, we'll go over that. But an easement by prescription through adverse possession. Sometimes this is referred to as squatters' rights. Now, squatters really have no rights, but if they've used your property against your permission, out in the open, hostile, adverse to the owner's title, it's visible, open, notorious, you've been using it, it's against the owner's permission that you've been using it, and you've been using it for a period of time as defined by whatever our state law's time period is, they could then take the owner to court and make a claim of adverse possession to take ownership of the property. Now, In New Jersey, the prescriptive period is 30 years for improved lands that they need to have used the property out in the open against the owner's permission, or 60 years if it's unimproved woodlands. Now, this law will change at some time in the future to the 20-year common law period. However, I've been following this for over 15 years now. They decided that they were going to change it. They know what they're going to change it to, and they still haven't voted to the actual change. So when is that going to happen? Who the hell knows? There's been so many versions of these books that come out, and they keep changing the law. They keep saying 30 to 60 years, and then next time they say it's 20 years. They jump the gun, assuming that the politicians in New Jersey would have already voted on this. Now that book was wrong, and it needed to be updated again. So it changed it back to 30 and 60 years, and then another version said 30 and 60 years in one chapter and 20 years in another chapter. And this version of the book says one chapter that's 30 and 60 years, and another chapter looks like it's going to be 20, or the law is, or they say the law is unclear. Well, I know what the law is. It's right now it's 30 years for improved lands to claim adverse possession, or 60 years for woodlands or wetlands. It's going to be changed at some time whenever politicians in New Jersey decide to vote on it. If they want to raise our taxes, if they want to create a new gas tax, they could do that in less than 30 days. Now they agreed to raise the the utility bills. Look at this. They're raising all these things, but yet they can't vote on something else that they're all in agreement on. And that is the prescriptive period for adverse possession. So for exams, even though we know that they're going to change it to 20 years at some point in time, for exams, they still have not changed it. So we're still going to study 30 years for improved lands and 60 years for unimproved lands. So through the process of tacking, successors in interest, like a landlord and a tenant, ancestor and an heir, or a seller and a buyer, can add one person's time of possession to that of another, combining them to reach a prescriptive period. Now, how can an owner prevent someone from taking their property through the courts if they've been squatting and using it? Well, an owner should take legal action against any adverse possessor. They should first walk their property at least once every 30 years, right? And then take action to get someone removed from their property that's been using it. So you take legal action against any adverse possessor, or you cut off their access. This would stop the continuous use requirement, and it also resets the time clock of adverse possession. Or you could just give them permission. That would also reset the clock, but actually it doesn't just reset the clock. You can't claim adverse possession against an owner who gave you permission to use their property, period. So that would also reset the clock if they were adversely using it and then you really wanted to get them removed. You give them permission to use it for a week and then say you got to get off. That reset the time clock, and that would prevent them from being able to claim adverse possession. Now, adverse possession cannot be claimed against publicly owned land. So easements by prescription, that's the official way to take it through adverse possession, cannot be claimed against publicly owned property. I just had somebody ask me about this because they've been using, I've got a friend who has a commercial building and a warehouse, and on the back street, this is like a street that backs up to a railroad, and it's a dirty street. It has not been cleaned, kept, or taken care of. But his block is spotless. It's meticulous. He's cleaned it, but then he goes back there and he started setting it up like it's his own backyard. You know, he even set up like a little basketball court back there, and you know, benches and all kinds of things. You know, it's really nice the way he set it up. But all the other properties along that road are filthy. There's garbage, there's all kinds of stuff. But his is meticulous. The mayor told him that, hey, he could continue using it for as long as he's mayor. He's like, he'll make sure. But now you got some people that are trying to ruffle feathers because they're not allowed to use the public street like he is because he's been maintaining it well. And now he's asking how he could keep this property. And I told him, you cannot claim adverse possession because he said, somebody told me about easement by prescription or adverse possession. I said, no, unfortunately, that's not an option. You cannot claim an easement by prescription through adverse possession of a property against publicly owned land. Maybe he could ask the mayor to do a public grant and give him the property or sell him the property. But unfortunately, that mayor is being eyeballed because he's been doing a lot of illegal stuff lately, and he doesn't want in the public eye, to show that he's selling somebody a piece of land for $1, even though he's done it in the past for his buddies. So you can't claim adverse possession against publicly owned land. All right. Now, let's do these highlights. Let me see. From chapter 20, page 375. Let's do these highlights on page 375. Adverse possession is another means of involuntary alienation where an owner may lose title to another person who has some claim to the land, takes possession of it, and most importantly, uses the land. In New Jersey, a person may acquire title by adverse possession through the continuous, open, notorious, hostile, and exclusive occupation of another person's property for 30 years. 60 years if it's considered woodlands. But after that time, the user may perfect a claim of title to the land through the legal process known as adverse possession by bringing a suit to quiet title. So through the process known as tacking, continuous periods of adverse possession may be combined by successive users, enabling a person who has not been in possession for the entire 30 years to establish a claim of adverse possession. But the process is not automatic. Legal action is necessary to perfect the claim of adverse possession for that suit to quiet title or a suit for adverse possession to claim the easement by prescription. So adverse possession is not possible against publicly owned property. Now, once an adverse user has established title and they win their claim of adverse possession, the former owner has no recourse. So to prevent such loss of title, every person having a right to title to real estate must inspect the property at least once within a 30-year period and take legal action against any adverse claims. So property owner who feels like the new government this one is interesting right here. This is not on exams, but it's interesting, and I've actually helped some people with this before. Property owners who feel like new governmental requirements have taken away their rights because they put in all kinds of zoning laws and they put all kinds of restrictions on how you could use your property. If they put in so many restrictions that they basically render your property, they decrease the value of it. They render it useless because of all the restrictions that the government put on there through all kinds of environmental regulations and zoning laws, etc. An owner can claim inverse condemnation. That basically, without actually claiming, without trying to make a claim to take away an owner's property, they actually took away their rights to use their property. So this is known as inverse condemnation, but the burden lies on the property owner who has to prove that all those governmental actions have taken their rights away without compensating them. And if they could win such an argument and such a suit, the government would be forced to reimburse that individual property owner for the loss of value for the use of their property or lack thereof. So this is what we're going to highlight when we go back to chapter 6. You don't have to go back right now. When we go back to chapter 6, you'll see this same slide again, and we'll highlight this stuff there. Okay. It's basically in chapter 6, they word things a little bit differently, and we're going to make some changes on the slide there. That's all that this is. But there's an interesting thing they show here, that a homeowner might give a neighbor written permission to garden the back of the homeowner's lot, making the use of the property no longer hostile to the owner's intent. So the owner of a shopping plaza or mall may often close an area of its property one night a year, restricting it to its use to the public. So to avoid the public making a claim that the public has gained an easement. So since the property cannot be accessed, this stops the continuous use of the property, even if it's only for one day. That resets the time clock for making a claim of adverse possession. You guys familiar with Rockefeller Center in New York City? They got that skating rink there. They put up the Christmas tree every year. There's different reasons that different areas of that property get cut off to the public, whether it's they put up a Christmas tree or they just rope it off for a day. Or they shut down the ice rink for a day. This is how they avoid the claims of adverse possession, because the public is always on that private property. That's actually private property. It's not a public park. It used to be owned by the Rockefellers. The Rockefellers, at some point, their family sold it off to some Chinese company, which is owned by the Chinese government right now. So the Rockefeller Center it's not even an American company that owns it anymore. But it's private. It's not a public park. All right. All right, so we got this here. Let me just back something up on my notes. I got to open up that my screenshot taker so that I can put one of these notes in the ClassLinks Word document that I've been maintaining. Just give me 1 second here. Beautiful, beautiful. Okay. That's done. Okay, so let me just go full size with the slideshow again, and we'll continue. There we go. So once again, we've seen this slide or one similar to it many times already. Title is just a word that means ownership. There's no document in real estate called title. Deed is a document used to transfer ownership, the title, during that person's lifetime. A will, the last will and testament, is a document used to transfer one's ownership after their death. Transfer of title by will is known as devise. The devisor is the person who's leaving you the property in their will. The devisee is the one named in a will to receive the property. Testate is meaning that you've prepared a will stating how to dispose of your assets after your death. Keep in mind, a will has no power until after you die. So if you name somebody, if you created a will and you name somebody in your will to get your stuff after you die, can you still sell that stuff while you're alive?
No.
Sure can. So what happens when you die then? Person gets nothing because you sold it. It's your property. Remember, a will has no power until after you die. So if you wrote in the will that you're leaving your house, 123 Main Street, to somebody, but during your life, you now sell that property. If you die later on, the person doesn't get that property because you sold it while you're still alive. So this is why you should update your wills periodically too. Transfer of title by descent takes effect when you die. Only after you die. Every state has their own laws of descent and distribution specifying how or who can inherit your assets upon your death when you die intestate. Remember, intestate means you have not prepared a will. It's a form of involuntary alienation because you're not the one that gets to decide who gets your stuff. If you had made a will, well, that will states who gets your stuff when you die. But if you didn't make a will, well, I guess you got no say in who gets your stuff. People can make claims against it, or the government can claim ownership. You know, should have made a will. Shoulda, coulda, woulda. All right, so let's see the book here. Let's do our highlights, make some notes on page 375 in chapter 20. So every state has a law known as descent and distribution that determines who gets your stuff when you die intestate. So highlight intestate is without having left a will, whereas testate means you did prepare a will, indicating how to dispose of your assets after your death. Now, legally, when a person dies, title to their real estate immediately passes to their heirs by descent or to the person named in the will. However, the will must be probated, and all claims against the estate must be satisfied, meaning all debts must be paid, especially any unpaid taxes or claims from creditors. And probate, or administration, is a legal process by which a court determines who inherits the property of a deceased person and what the assets of the estate are after all debts have been paid. Either an executor or an executrix named in a will, or an administrator appointed by a court, if no executor or executrix was named in the will, oversees the administration and distribution of the estate and your will. So once again, here's that. We've had this in chapter 5, and now here it is in chapter 20. You know, an heir is a natural blood relative who can inherit the belongings of a relative who had died. They can make claims that if their uncle dies, that they could make a claim that they're a relative, and they can make a claim to those assets that the uncle left behind if he didn't have children or a wife or something, you know, and he didn't have a will. Who can actually lay claim to your stuff? Heirs. Now, we're going to get into more detail of that just for your own edification, but not for exam purposes in just a moment. Devise is when you transfer property by will upon death. Devisor is the one who is leaving their property in their will, and the devisee is the one who was named in a will to receive it. Every lease has a demising clause, but demise should not be confused with devise. They're so similar, which is why we have them together here in the list of death terms. Demise is not a death term, even though it sounds like it. You finally met your demise. It is not a death term. Every lease has a demising clause in it that says the landlord is to let the premises and the tenant is to take possession. Testate means you made a will. Intestate means you did not. Testator is a man, and testatrix is a woman who made a will. Probate is that court proceeding that determines who the natural heirs are, or to confirm who the devisees of an estate are, no matter if you had a will or not, and what the assets of the estate are after all debts have been paid. An executor is a man, and an executrix is a woman. They are a trusted person that you would name in your will to ensure all of your final wishes are carried out as you wrote in your will. And they're in charge of distributing all of your assets according to your final wishes. And if you didn't name an executor or an executrix, the court will appoint an administrator who will do it, usually an attorney, in exchange for a fee, but not always an attorney. Descent and distribution, once again, is the laws that only come into play when you die intestate and no natural heirs can be located. Escheat is when you die intestate and no heirs can be located, where the property would revert to the state. The state would sell the property at an auction and hold the money in a fund for a year, in which time you could lay claim to it, or one of your heirs can. Anybody look up missing money yet, or unclaimed property?
I did.
Anybody find anything?
I found something under mine, but I didn't go into it. I just saw.
You know, hey, it's missing money. That's found money. You know, it doesn't matter if it's a couple bucks or a couple hundred or $1,000.
It
You know,
said something like property, and I was like, wait a minute.
even better. All right.
I
Well,
mean, I would have to finish the process, I guess, to see what it is.
yeah. In some cases, they tell you outright what it is, and others you got to fill out a form and lay a claim before they tell you, because of some things in there have privacy to them, and others don't. They just openly tell you right out. You know. So you just got to fill out a form, submit it, and they'll tell you what it is.
Got it.
Okay. Great. Good for you.
I saw
I owe you 10%.
my father's name on there. And it has the address where we used to live at too.
Tell your dad, print out the forms. You're going to get something. See, this class is paying for itself already.
That's interesting. Oh my gosh.
Yeah. Missing money. Now it's found. It was once lost, but now it's found. Congratulations, guys. All right, so escheat is once again okay, we already went over that. Legacy and bequest. A legacy is your personal property that you leave behind, that you've amassed during your lifetime. You know, your tools, your motorcycle, your car, your boat, your jewelry, your whatever it is, you know, your money. That's your legacy that you've built up over the years, and a bequest is your wishes of who you wish to get your stuff. I bequeath to thee my vast fortune of $4 in my bank account. Hopefully you don't have a lot of money to leave behind, at least if you don't have kids, you know. Well, you know, hell, even if you do, hopefully you taught them to how to make it on their own, you know. And, you know, you've enjoyed all of your money during your life because you can't take it with you. Right? Enjoy it now while you're here. A lot of us, I know we think that we're immortal, especially when we're younger. You think, hey, I got my whole life ahead of me. Yeah, but you know what? That life could end at any time. It's at his will, right? So, um, the dower and courtesy. Once again, these dower begins with a doe, and a doe is a deer, a female deer. So that is the wife's right in the husband's property that he owned during their marriage. Courtesy is a similar right that the husband has in the wife's properties that she owned during their marriage. So dower and courtesy rights are ancient rights in New Jersey that have been the state of New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. So you need to know what dower and what courtesy is. Dower is the wife's right in the husband's property. Courtesy is the husband's right in the wife's property. And I remember this by dower begins with a doe, and a doe is a deer, a female deer. So that's the wife's right. And men should be courteous to women. So courtesy is the husband's right. And May 28, 1980, hell, you just need to be able to memorize that. That's the date where New Jersey abolished the creation of new dower and courtesy rights. But any existing ones that were already out there are still in existence. It did not terminate or abolish any existing rights. It just abolished the creation of new ones. So people who are married after this date have the rights and interest in the primary marital residence only. And of course, anything else that you may have left your spouse in your will. Remember, you can't write your spouse out of your will. Well, you can, but if your spouse knows the law, they could just be like, I'm going to exercise my right of election. This is the right that's only reserved for a surviving spouse to say, there's certain minimums in the state of New Jersey that your spouse has to leave you in the will, and that's 1/3 of the estate. Once again, missingmoney.com, that's a government-owned website where you could search for Money New Jersey. Used to subscribe to this and put all of their missing assets and money and stuff in there. And you may still be able to find this because maybe some companies are still putting things in there. So, but that's a national basis, unless a specific state is using their own unclaimed property page. Like New Jersey used to subscribe and use the missingmoney.com app, and then they changed their mind and said, you know what? We want to create our own. We don't want to give up control to anyone. So New Jersey created their own version of that website called unclaimedproperty.nj.gov. That's New Jersey's missing money page. Neither one of these you should be using credit cards or anything like that. They're free, they're government run. So if it asks you for a credit card, you are on the wrong website. I keep saying this because I had a student before that said they went to missingmoney.com and they entered their credit card info, but then it didn't show them anything. And I said, then you were not on their website. I was like, you typed in missingmoney.com in the search bar, right? And they're like, yeah. And actually what they did, instead of putting it in the address bar, they actually went to Google and typed in missingmoney.com and got the results. And the first results are paid advertisers, of course. They clicked on one of these ones that said missing money, and it took them to some bogus website that asked for credit card information. So this is what I'm telling you guys. It's not going to ask you for your credit card information. Okay. All right. So continuing on. Let's do these highlights. A last will and testament is an instrument made by an owner to voluntarily convey title to the owner's property only after their death, because a will only takes effect after one's death. Until that time, the property can be conveyed by the owner. It's your property. You could sell it. You can do whatever you want with it. Give it away. So a party who makes a will is known as a testator or testatrix, and the gift of real property by will is known as devise. Okay, in New Jersey, children can be disinherited, so be good to your parents. Actually, you shouldn't just be, I shouldn't say it that way, because you shouldn't be good to your parents hoping that they're going to give you something or leave you something. You should always be good to your parents. You know, in New Jersey, though, children can be disinherited. Your parents can write you out of the will. But a surviving spouse is entitled to at least 1/3 of the estate, and the determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they're going to take the statutory share rather than any lesser share that may have been provided for in a will. This is called the right of election, and it's only reserved for a surviving spouse. So if you wrote your spouse out of the will or you left them less than the amount that the law requires you to leave, your spouse can be like, no, I'm going to take the share that the minimum you were required to leave me by law, which is at least 1/3. So there you go. If your spouse dies and they left the majority of the estate to their girlfriend, you could still say, no, I don't think so. I'm entitled to at least 1/3. Anybody catch the joke in there? Okay, I'm trying to be humorous. Okay. All right, so a will differs from a deed in that a deed conveys a present interest in real estate during the lifetime of the grantor, while a will conveys no interest in the property until after the death of the testator. So to be valid, a deed must be delivered during the lifetime of the grantor. So this is why deeds are not dated. Because when does the property ownership actually transfer? Upon delivery and acceptance of the deed itself. The person who's buying or getting the property should be named in the deed. But deeds don't need to be dated or signed by the buyer. They only need to be signed by the seller. And the buyer needs to be named in the deed. And the transfer of ownership takes place not by any date, by the delivery and acceptance of the paper, the deed itself. So the parties named in a will have no rights or interest as long as the party who has made a will is still alive. They acquire interest or title only after the owner's death. All right, so you guys got all these highlights and this little note here I put on the side. See page 120, remembering legal terms, OR versus EE. That's where that chart that I spoke of before will be at, showing that words that end in O is the person who's giving, whatever the root word is. Words that end in EE, that's the person who's receiving. So that's basically what they explain to you on that chart. You know, like who's the lessor? Who's the lessee? Well, what's a lease? A lease is a property where an owner intentionally transfers the property and the rights to it to a tenant for a limited period of time as defined in the lease. So the person who gives the lease is the lessor, that's the landlord. And the one that receives it is the lessee, that's the tenant. See, doesn't that make it so much easier to be able to identify who the folks are? Oh, there's the person who's giving whatever the root word is. EE, words that end in EE is the one who's receiving whatever the root word is talking about. Okay. Everybody got the highlights and notes? Can I turn the slide?
Not yet, teacher. Hold on.
I'm good.
Okay. I just want to know. I'm not rushing anybody. I just take your time. I just want somebody to let me know so that we're
Got it.
okay.
So, teacher, I have a question. So if my dad has unclaimed money, like with this website, can I still claim it and like provide documentation that?
Is your
Well,
dad
yeah, he's alive.
okay? Well, he has to claim it
Okay,
unless he gave you a power of attorney so that you can.
got it. Hold on. And I got the highlights too.
Okay. Anyone else still need time? Okay, guess not. Oh, so here's that chart that we're going to see in chapter 7, OR versus EE, remembering the legal terminology. You know, it gives you the root word, or they call it the product. I call it the root word. So you, as long as you understand what the root word is, the word that ends in OR is the person giving the product, and the words that end in EE is the one that's receiving it. So we'll go over this in chapter 7, but this is just a little chart. So, you know, devise is when you leave property by will to somebody. And the devisor is the one who left the property in a will. The devisee is the one who's receiving it. So here are the legal requirements to make a will, in case you were wondering. Anybody who's of sound mind and legal age can make a will. You got to be at least 18 years of age or old. Wills need to be in writing. You cannot have a verbal will, like you can't do a videotape just for dramatic purposes. Well, you could do a video that where you're reading your will, perhaps, but the video will should not be contradictory to the actual what's in writing. What's in writing is the only thing that matters. What you say, if you have a video will, it's not valid in New Jersey. It must be in writing. So anybody who's 18 years of age or older can make a will. And the general rule is that a will must be witnessed by 2 people, and a beneficiary can serve as a witness. But their signatures should be notarized as soon as possible. So a holographic will is a completely handwritten will and doesn't require any witnesses. The person, let's see, under New Jersey estate planning law, holographic wills can be probated and will serve to ensure that the testator's assets are bequeathed according to the testator's wishes. And remember,
one quick question. So, like if we're writing a holographic will, we don't need to go for the lawyer. You can write it yourself, correct?
Yeah, holographic will, you could write it yourself, completely handwritten. Just make sure.
That is the better, that we don't need any witness and all those things. So this is the better will.
Just make sure you know everything that needs to be added into the will. You know, some wills can get kind of complicated too, that they start talking about like what's it, the living a living will. You know, like if you're you can't function, you're in a coma or something, who's going to make the decisions on your behalf? You know, how do you know, all these types of things. What, you're not dead yet, you know, but you could put the power of control into somebody's hand to make certain decisions for you if you need to be cared for. Because of an illness or something, or an accident or something happens, should you be like brain dead, or if you know, you just in a coma or something of that nature, you know, who can make the decisions for you, whether to pull the plug or not, for you know, for instance, you know. And that's actually pretty important in New Jersey, because New Jersey being the wacky state that we are, every politicians here, Mr. Murphy, the politicians in control of the state house there in Trenton, thought it was a very nice thing to do to pass a law to allow people to who no longer want to live to be terminated. You know, the assisted suicide type thing, you know, that's actually legal here in New Jersey. Who would have thought? You would think that that would only be like something that Californians would do, but they got that here in New Jersey too. Yeah, we're kind of extreme here. So New Jersey does have a law like that. And even though the person needs to be of sound mind enough to be able to think for themselves, to say, I don't want to live, I've seen an instance where a roommate in a hospital bed of one of my parents, they shared the same hospital room. The lady was here one day, gone the next, and the nurse shared quietly something that they shouldn't have, saying that, yeah, the family did that assisted suicide thing for them. However, that lady was not of sound mind. She was like constantly screaming and like in one time babbling the other, you know, it's like not of sound mind at all. So who's monitoring this stuff really? Probably the kids that are doing, probably the people that are doing the sex changes for kids, right? Are they really getting the proper permissions and stuff? You know, so that's kind of a scary thought. So for a real property acquired by a married deceased person before May 28, 1980, when they abolished the creation of any new dower and courtesy rights, the surviving spouse is still entitled to a life estate of one half the interest in all real estate owned by the deceased, no matter what other provisions were made for in the will. My screenshot taker. All right. Of course it closed again. No, it's open. I just couldn't get to it. No. So I just need to take another screenshot here of something. La, da, 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 da.
You mean you're using a snip tool?
The snippet tool.
Yeah.
Yeah.
Excellent.
Yeah, but I'm switching between all these windows with Zoom open and everything. Sometimes it's accessible, sometimes it's not. It's kind of a bit of a pain in the butt, especially when I got like 8 windows open right now. All right, move to that slide. So I'm going to try to keep that open on screen for you guys. I have full screen, the slideshow here. So put that back at the full screen. There we go. And now we turn to this. The transfer of title by descent. Title of real estate and personal property of a person who dies intestate would pass to their heirs under the descent statutes of your state. Now, the primary heirs, can you guys see this as it's being shared with you? There we go. So the primary heirs of the deceased are your spouse, civil partner, or domestic partner, and close blood relatives. And when children have been legally adopted, most states consider them heirs of the adopting parents, but not heirs of the ancestors of the adopting parents. You see, some of these laws seem like they're kind of like from medieval times still, and they are kind of old, you know. Let's continue on with this next sentence. In most states, illegitimate children inherit from the mother, but they do not inherit from the father, unless he admitted parentage in writing or parentage has been legally established in some other way. And then if he legally adopts such a child, their real blood relative child, that child inherits like an adopted child would from the parents, but not from the ancestors. Okay, so that leads us back to the question then. What is an illegitimate child? Anybody know?
No.
Someone you just say is your child? That you
It's-
haven't really.
No, it's when you are born and your parents were not married when you were born. You're an illegitimate child. Or if anybody ever watched Game of Thrones, you are the bastard child and you cannot lay claim to be king. You know? So I thought it's kind of like some type of laws here. And when I put it that way, yeah, sounds like it, doesn't it? But that's the law. You don't like it? Have your politicians change it. But that's been the law for a long time here. And it's kind of crazy, isn't it? That if you're born out of wedlock, your parents were not married, you're considered to be illegitimate, but you can inherit from the mother, but you can't inherit from the father unless he admitted to being your parent, or it was proven legally in some other way that he is your parent. And then in that case, you could only inherit from the father, but not from his side of the family, which is kind of weird because you are their actual blood child from the fruit of their loins. You know, it's like, so it's kind of wacky, to be quite honest. But those are the laws.
Illegitimate child.
Yeah. Something, huh? Come on, why is the snippet tool not staying in focus? I gotta minimize this again, take another screenshot. I don't know what's up with the snippet tool. Snippet tool kind of sucks. Oh, I jumped way ahead. All right, so now that we got that down, who can claim if you die intestate without a will? Who can lay claim to your estate to inherit assets? Well, once again, every state has their own laws of descent and distribution, but they only take effect if you die intestate without a will. So even in that case, the estate still needs to be probated, and whatever is left over after all debts have been paid, then get distributed to your heirs, those natural blood relatives that can lay claim to your estate. So the laws of descent only take effect when you leave my will. Your surviving spouse or partner become the sole heir if this descendant leaves no parents or children. If there is a child or children who are also children of the surviving spouse, the spouse or partner receives the first 50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and the spouse but no children, the spouse or partner receives the first $50,000 plus 1/2 the remaining estate. The rest goes to the parent or parents. If there are children who are not the children of the surviving spouse, maybe he got remarried, the spouse or partner receives half of the estate and the child or children the other half. Where no spouse or partner survives, children become sole natural heirs. And where there is neither a surviving spouse nor children or children's own heirs, the estate first goes to parents, and failing that, to brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins may be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey by escheat. So the state treasurer would sell the property at a public sale, giving notice by publication in the newspaper in Trenton and the newspaper in the county where the property is located. The proceeds of the sale are held in a fund for 1 year, missingmoney.com or unclaimedproperty.nj.gov. And if no claims are made within the year, the state keeps the money. That's how escheat works. They escheat you out of your property. All right. So there, once again, go to unclaimedproperty.nj.gov. That's New Jersey's website, or missingmoney.com to search and see your name, your relatives' names, and see what comes up. If you find something, file the claim, or tell them about it so they could file the claim. And that concludes chapter 20. So let's do the key terms to review for chapter 20. Oh. Let's do the key terms to review for chapter 20. And we'll start that right now. After I get the screenshot of that last slide. To add to our notes. And we're off. So chapter 20, key terms to review. It'd help if I turn to the page. Let's see.
Oh,
All right, there's only one key terms to review for this chapter. And before we get started, go down to letter L, and at the end of the line where it says one who can inherit, write blood relatives. At the end of the line, blood relative.
yeah.
And next to the number 5 where it says executor, put a slash and write executrix. EXECUTRIX. Executrix.
Yeah, it says male and female. Means
Yes, because they're genderized, they're gendered terms, yeah. And at the same token, go down to number 12 and put a slash and write testatrix. Test, T-E-S-T, the letter A, T-R-I-X. Testatrix.
Can you say that one more time?
Sure. Next to number 12, where it says testator, put a slash and write test, T-E-S-T, A-T-R-I-X. Testatrix is the way it's spelled. Testatrix. But it's pronounced testatrix. Executrix and testatrix. Those are the female versions of executor and testator. Okay, and once we got that, we can get started here. So let's do this. A person named by the state to administer a descendant's will. What do we call a person named by the state?
Administrator.
Yes, they are an administrator. Known as A. Court proceeding to establish the validity of a will.
Probate.
Probate.
Probate?
10 is B, yes. Title acquired by usage, when you've used a property.
30
Uh,
years.
Adverse possession, to receive. Person named in a will to administer the descendant's estate.
That is the devicee.
What do you call the person that you named in your will to distribute your assets according to your wishes?
Executor?
Executor.
Executrix, correct? It is D.
Wait, which one is that again? Wait.
5 is D. 5 is David.
Like is D? Okay.
Like in David. D as in David. Correct. Transfer of title, let's see. Yeah, transfer of title without the grantor's consent.
Involuntary alienation.
Is involuntary alien. 8 is E, that is correct. Without being prepared to.
You repeat that?
Yeah, when you died without a will.
Without a will.
I'm just gonna mute it really quick. You guys can answer again because it's got some chatter in the background. It's making a lot of noise. So you guys are not hearing everything. So let's repeat that one again. Transfer of title without the grantor's consent.
Involuntary alienation.
8 is E, involuntary alienation. Then we have without a will. What do we call it when you do not have a will? You die without having prepared a will.
Intestate.
Intestate.
Testate. 7 is F, correct. One who makes a will.
Testate.
No, the person who makes the will.
Testatrix.
Last will and testament.
Testator, testatrix is what you call the person who made the will. 12 is G. A document disposing of property after your death.
Last will and testament.
Last will and testament is correct. 9 is H. What do you call it? You did make a will.
Device.
No?
Testate.
With a person. Yeah, testate. Correct. 11 is I, testate. Acquiring a property by natural
Heir.
Heir.
Descendant.
Of property by natural heirs. Descent. Somebody said descent. That's how you pronounce it. It's descent. Remember, every state has their own laws of descent and distribution, so it's descent. So 3 is J. One who receives real property.
Devisee.
Devisee.
Would be a devisee, which is a person that you name in the will to receive yourself. 4 is K. 4 is K. One who can inherit, those blood relatives who can inherit. They don't need to be written into a will, but they can inherit.
Heirs.
Heir. 6 is L. 6 is L, an heir. Transfer of title with the grantor's consent.
Last one, M. You don't have an option.
13 is M, as in Michael. Correct. And that concludes chapter 20.